everyone, my name is Victor Manibo. I'm a senior attorney here at Wang Law Office. You are watching the AM show, Wang Law Office's question and answer show.
Hi, my name is Ariel. I'm the host, also a senior paralegal at Wang Law Office. Our show is going to start every Friday at 11 a.m. EST, 8 a.m. PST.
Here at the AM show, we try to answer all your most pressing immigration questions. We get questions from our viewers via Line, YouTube, and all our other platforms, and we collect them into one weekly topic. This week, we're going to talk about criminal histories and convictions. How does that affect any pending applications or potential applications? Or how does that affect someone's LPR status? We're going to go into all of that and any strategies to address and to deal with those complicated matters.
So, Victor, before we start today's topic, can you introduce yourself a little bit?
Sure. For those who haven't met me yet, again, my name is Victor Manibo. I'm a senior attorney here at Wang Law Office, and I've been with the firm for over 10 years. I've been a lawyer for over 12 years, and I graduated from Cardozo School of Law here in New York. I'm licensed to practice in New York and New Jersey, but because I do immigration, it's federal, so I can practice anywhere in the United States. I can practice immigration law. Most of what I do is immigration litigation, meaning I help non-citizens and defend them in immigration court. I also do immigration applications, meaning I help non-citizens apply for valid immigration status with our various immigration agencies. Aside from being a lawyer, I'm also a science fiction and fantasy author, and my first book, The Sleepless, came out last year in August.
If I have a criminal case, will it affect the family-based green card application?
Yes, it could affect your green card application. That depends what you mean by criminal case. Is it ongoing? Is it already over? It also depends what kind of case it is. Why do you have a criminal case, or why was a criminal case brought against you, and what was the outcome of that? And depending on the answers to those questions, it could impact your green card application. It's just a part of our immigration process. Before giving status to any non-citizen, USCIS has to make sure that you haven't had any trouble with law enforcement that would disqualify you in any way from getting a green card or from getting any sort of status.
Do all criminal cases affect my green card application?
Not every criminal case or criminal offense will negatively affect your green card application. Under U.S. immigration law, only criminal convictions can affect your green card applications, and only certain types of convictions can affect it. It's going to have to be an aggravated felony or an illegal drug conviction or a crime involving moral turpitude. Those are basically the three categories of crimes that make you what's called inadmissible, meaning you cannot be let into the country and therefore you cannot get your green card or lawful permanent residency. Not all crimes are going to fall under those categories. And again, they have to be convictions. So you have to be found guilty. The case has to be over and you lost.
So you mentioned the word conviction, right? What is a conviction?
Our immigration laws are very specific on what a conviction means. It's specifically defined in our laws. It describes a situation where a court has found someone guilty of a crime, or where somebody pleaded guilty to a crime, even if the court did not list it on your record. So for some people, you might have a conviction even though you don't have a criminal record, because some states can try to rehabilitate someone or remove a conviction from your record so that you can move on with your life. But under immigration laws, that might still qualify as a conviction. So an immigration lawyer can help you figure out, is your criminal case over? Is it a conviction or is it something else? And of course, if your case is still ongoing, a criminal attorney who also knows immigration, or an immigration attorney who also knows criminal law, will help you avoid a conviction. so that it won't impact any pending applications or any future applications.
Yeah, you are mentioning us. We are doing both at the same time.
Yes, exactly. That's something that Wang Law Office does a lot, both criminal and immigration.
Yeah, so how about if I have a conviction and I am applying for asylum?
So we talked about, you asked about green card applications. Some people are applying for asylum. Criminal convictions can also affect pending applications for asylum or future applications, because under our asylum rules, you cannot be convicted of a particularly serious crime. So this is a little bit different from what I was talking about with green cards. I was talking about aggravated felonies, drug convictions, crime involving moral turpitude. That's for LPR status, and we'll go into those terms a little bit more. But here in asylum, I'm introducing another new term, particularly serious crime. That's the legal standard for asylum. And particularly serious, it depends on like a case-to-case basis. It's defined in our immigration cases, but it's not specifically listing out what kind of crime is a particularly serious crime. But from the sound of it, right, particularly serious, that's maybe when someone hurts somebody. A lot of aggravated felonies are also particularly serious crimes, but not all particularly serious crimes are aggravated felonies. Again, these are very specific terms. If you're not sure about what your case is about or what the consequences of your case might be, especially if you have asylum and you think your case is or the crime is serious, then it's really a good idea to consult with a lawyer who knows these things.
So what about if I am applying for naturalization?
Let's say you already have your LPR status and now you want to apply for citizenship. Some criminal convictions can affect your potential eligibility for naturalization, because to naturalize, to become a US citizen, you have to prove that you have good moral character. Again, this is another new term. Good moral character basically means you are a good person. Having a criminal history is part of that. But there are other things that are part of good moral character, like do you pay taxes? Do you pay child support if you're required to pay child support? Or have you ever lied to immigration in the past? Those all indicate whether a person is a good person or not, aside from criminal history. So criminal history is a factor when it comes to good moral character. If you have a conviction, USCIS might find you do not have good moral character, but not always, because good moral character has a lot of factors in it. So if there are good factors in your case, it might outweigh your criminal conviction. But just know that your criminal convictions, especially those that are within 5 years before you apply for citizenship, can be considered in this good moral character analysis. And if you have one, it might negatively impact it.
What about if I am being petitioned by a relative?
So we talked about this before, and I keep saying this, a relative petition, it's not status, right? It only establishes the relationship between the petitioner and the beneficiary. Are they really relatives? Are they really eligible for one of the categories for family-based relief? So when you're thinking about petitions, a criminal history is not relevant to that. USCIS doesn't ask that. But you have to think about, what is this petition going to be used for afterwards? Relative petitions are used for green card applications. So even though the relative petition gets approved, regardless of a criminal history, that criminal history is going to come up when you apply for green card afterwards.
Yeah, so do I have to inform USCIS about my criminal case?
Let's say you are applying for an immigration benefit, or you've already applied. It depends, right? If you're just about to apply, you're about to file for a benefit application. Some benefit applications ask about your criminal history, ask about not just convictions, but ask about arrests. Even though you've been found innocent, even though your case has been dismissed, USCIS will still ask about it in those forms. And you will have to provide proof about those criminal cases. So the answer to that is like, if USCIS asks for it, then yes, you have to inform USCIS. And these are usually criminal history, not just within the US, but anywhere in the world. You have to be truthful and honest in reporting everything to USCIS, including your criminal history.
What kind of criminal case that I have to inform USCIS? How should I inform them?
With USCIS, their forms can be very specific. They'll ask for arrests, they'll ask for convictions, they'll ask for the outcomes, if it's ongoing or if it's already over. So those details have to be provided. Some forms will even ask for dates. So you have to provide those. And for some forms, you have to provide some documents about those criminal cases. So you have to be prepared if you have an ongoing or already over case. You have to be prepared to answer all these questions and provide supporting documents.
Our office does both criminal and immigration. If you have a criminal case, better to consult to see if it's going to affect your immigration status, the current one, or the pending application.
Right.
So any consequence if I fail to inform USCIS about my criminal case?
If you hide a criminal history, it's not going to be good. You know, I always tell people, be honest, even though you think it's bad. And criminal history, it does sound bad, right? But it's even worse to have criminal history and then lie about it or hide it. It's only going to hurt your chances of getting a green card or any status that you're applying for. USCIS does background checks. You know, when you apply for a benefit, they usually, almost for all benefits, they ask you to do biometrics, which is you have to show up at a USCIS office. They take your photographs, they take your biographical information, they take your fingerprints. And then from that, they can do a background check on you and see if you have any criminal cases, arrests anywhere in the country or the world. So even if you don't put it on your form, they're going to find out about it. And if they find out about it and you didn't put it in your form, they're going to be very suspicious. Why are you lying about it? Why are you hiding this? And it's not going to look bad. So again, I keep saying this, just be honest. And if you have a good lawyer, being honest about your criminal history is just one thing. There's also the added layer of knowing how to argue that criminal history and knowing how to present that criminal history so that you can convince USCIS to still grant you the application despite the criminal history.
So what if I already have the green card and then I got a criminal conviction? Do I need to inform USCIS about that?
So this is the other scenario, right? What if you already have the status? In this case, you already have a green card. You're not required specifically to inform USCIS that you got a criminal case or you got convicted if you already have your LPR status. Even if you're renewing your green card, they don't ask you if you've been convicted in the last, since you got your green card, right? So you don't have an affirmative obligation to write USCIS and say, hey, by the way, USCIS, I know you already gave me a green card, but I just got this criminal conviction. You're not required to do that. However, if you have a green card and then you apply to become a citizen, you have to disclose that information. That's required in your naturalization application process. Now, even though you're not required to tell USCIS about any criminal convictions after you get a green card, USCIS and ICE might still find out about it because our immigration agencies, they check up on these things. They communicate with criminal courts all over the country. So if you have a conviction that is serious enough, ICE might find out about your conviction even though you don't have to tell them about it. And then when ICE finds out about it and it's something that could make you removable or could give them a reason to take away your green card, ICE can do that. ICE can say, oh, we found out about your criminal conviction. We're now going to take away your green card. We're going to send you to immigration courts.
Why can they do that if I already got the green card?
Well, they can do that because having a green card doesn't mean you get to commit crimes, right? You still have certain obligations. Being a green card holder has certain obligations that are attached to it, and it's still at risk of being removed. You are not a U.S. citizen yet. You just have permanent residency, and permanent residents can still be removed, can still be deported from the country. One of the reasons why permanent residents can be removed is if they get criminal convictions that are serious enough. Again, these are the aggravated felonies, the drug convictions, and crimes involving moral turpitude if you have more than one. These things make you removable. So even though you already have a green card, ICE has the power to take that green card away, kick you out of the country if you get convicted of those kinds of crimes after you get your green card.
You mentioned some of the consequence. What? You mentioned some of conviction, right? So can you tell me what kind of conviction can get my green card taken away besides the one that you just mentioned?
So let's start with the crimes involving moral turpitude. They're called CIMTs. If you have two of these, and depending on when you got convicted for these, how soon after you got your green card you got convicted for these, having two CIMTs or more might get you deported, might get you your green card taken away, send you to immigration court, and then like we found you removable, you'll be put on a plane. And these crimes involving moral turpitude, they're defined in our immigration cases, and these are usually crimes that involve fraud, deceit, violence, something that really shows that if you commit this crime, there's something wrong with you morally. You are morally depraved. Now, that's kind of a very broad category, but our immigration laws have a lot of cases that identify, okay, this is a CIMT or this is not a CIMT. If you get convicted of these crimes, your green card could be taken away, you could be removed.
Can you give me some example of aggravated felony?
Yeah, so aggravated felony is another category of crimes that could get your green card taken away. These crimes are listed specifically in our immigration statute. So there's a list you can check. And if your conviction falls under one of those things, then it's an aggravated felony. And these crimes, aggravated, that means super serious. These are what we think about when we think of serious crimes. These include murder, these include rape, these include sexual abuse, kidnapping. They also include some sort of theft offenses and burglary offenses, not all of them, but some of them. Any crime that involves violence, crimes that involve weapons, crimes that involve fraud, especially when the loss is $10,000 or more. So a lot of crimes can fall under aggravated felonies, but these are mostly the super serious crimes. And if your conviction fits one of these things, then you're at risk of losing your green card.
So what about the drug-related crimes?
Drug-related crimes, these are controlled substance offenses. So these include any conviction that involves any controlled substances that are defined in federal law. And it involves either drug trafficking, meaning selling, buying, or distribution, giving it to someone, being in the business of basically illegal substances, or sometimes even for personal use. So if you have a conviction that involves drugs, that is at a high risk of being a controlled substance offense, and that might lead to you losing your green card.
So you mean that the case that is related to any drug conviction, that means no green card?
Well, there's an exception to this if you only have one drug conviction and it's only for 30 grams or less of marijuana, then you may be able to apply for a waiver. We talked about waivers in the past. It forgives certain problems in your case, and there is a waiver for some criminal offenses. And one of the things that this waiver forgives is drug conviction for 30 grams or less of marijuana. So if that's your only conviction, then you might be able to get that waived. But generally, for drug convictions, that's going to be a really big problem, and you could lose your green card.
So what is the waiver that you just mentioned?
This is a waiver of inadmissibility, similar to other waivers that we talked about before, like the fraud waiver, right? It's gonna forgive certain crimes, but not all of them, okay? It will make sure that even though you have a criminal history, if you can show that there's hardship to your family members, you could still be able to get LPR status.
So can I get a waiver for all the criminal conviction?
No, unfortunately, this waiver does not apply for all criminal convictions. You can't waive aggravated felonies because our law treats that very seriously. But you might be able to waive crimes involving moral turpitude. And again, the drug conviction, that's for a small quantity of marijuana for personal use. But aggravated felonies, you can't really waive that.
So any requirement for this waiver?
For this waiver, if you are applying for this, you have to prove that you have a U.S. citizen or LPR spouse or parent who will suffer extreme hardship if you're not here in the United States with them. So you'll have to prove that there's going to be hardship to them in terms of their medical needs, their financial needs, and their emotional needs. You also have to show that you have changed your behavior, that even though you've already been convicted, you've rehabilitated, you've recovered from that, you haven't done anything bad in your history after that conviction, and that you're not going to harm anyone else in the United States. Waivers are very complicated. We have other episodes that discuss all of these kinds of waivers. I advise everyone to check out those episodes. But again, there is a way if you have certain kinds of criminal convictions to get it waived, so you might still be able to get your green card or your LPR status.
Yes, and you need to hire a lawyer who understands the consequence of a criminal case, whether you are applying or already have a status. Our office have more than almost 20 years of experience, both in criminal law and immigration law. We know how to handle those cases in the best way.
Absolutely. And again, these things are very serious. Not everyone can handle both a criminal case and an immigration case. So make sure that when you're making decisions about both of these kinds of cases, know that one case can impact the other, and you need a lawyer who can understand both areas of law.
Yeah, and if you have more questions, feel free to leave your question with any of our platform.
And aside from leaving your questions, you can also consult with us. We've come to the end of the show, and this is where I remind everyone that what I've been talking about here is based on my legal experience and is my legal opinion, but it's not legal advice. It's not advice specific to any one case, and it's obviously not legal representation. It doesn't mean that by watching this, you are a client. However, if you want legal advice specific to your case, and if you want to hire us for yourself or for your family members, please feel free to consult with us. You can book through any of our platforms. You can reach us through Line or our website, your email or phone call, any way that's convenient for you.
Yes, and please continue follow us on YouTube. We will be back again next week with another show, Friday at 11 a.m. EST and 8 a.m. PST. See you then.
See you next week. Bye.